Can an employer lower your pay in Illinois? The short answer is yes, but with important limitations that protect workers. Illinois employers can reduce pay rates, but they must follow specific rules and cannot do so for discriminatory or retaliatory reasons. Illinois labor laws require employers to notify employees before implementing any wage reduction. This means your employer cannot surprise you with a smaller paycheck. They must inform you of the change before you perform any work at the new rate. Pay reductions in Illinois must comply with minimum wage laws. As of this recording, the Illinois minimum wage is $8.25 per hour, though some localities like Chicago have higher minimum wages. Any reduction that brings your pay below the applicable minimum wage is unlawful. At-will employment is the standard in Illinois, meaning employers can generally change employment terms, including pay, for almost any non-discriminatory reason. However, employees with employment contracts or those covered by collective bargaining agreements have additional protections against arbitrary pay reductions. When is a pay cut illegal in Illinois? Several scenarios make pay reductions unlawful. If your employer reduces your pay based on protected characteristics, such as your gender, race, age, or disability, this violates both state and federal anti-discrimination laws. Pay reductions cannot be retaliatory. Your employer cannot lower your wages because you filed a workplace complaint, reported safety violations, requested reasonable accommodations, or engaged in other legally protected activities. If you have a written employment contract or are covered by a union agreement, your employer must honor those terms. Any wage reduction that violates contractual obligations is not permitted under Illinois law. The Illinois Wage Payment and Collection Act establishes clear notification requirements. Employers must inform employees of any wage reduction before the change takes effect. You cannot be required to work at a reduced rate without prior notification. Many employers provide this notice in writing to create a clear record of the change. Pay cuts affect different types of employees in different ways. For hourly workers, employers must maintain proper time and pay records and ensure wages don't fall below the minimum. For salaried employees, reductions must not drop compensation below the threshold for exempt status under the Fair Labor Standards Act. Contracted employees have protections based on their specific employment agreements. Union workers typically have wages set by collective bargaining agreements that employers cannot unilaterally change. Instead of reducing hourly rates, some employers choose to cut scheduled work hours. This practice is generally legal if employees receive proper notice and the reduction doesn't violate any contracts. However, reducing hours in response to protected activity can constitute illegal retaliation. If you believe your pay was reduced illegally, you have options. You can file a complaint with the Illinois Department of Labor, which investigates wage violations. You might also consult with an employment attorney to assess whether your rights were violated under state or federal law. Successful wage claims may result in awards of back pay, reinstatement to previous wage levels, and in some cases, additional penalties against the employer. Under certain circumstances, you may also be entitled to liquidated damages and attorney's fees. Understanding your rights regarding pay reductions is essential for all Illinois workers. While employers have the legal ability to adjust compensation, they must do so within the boundaries of the law. Advance notice, compliance with minimum wage requirements, and non-discriminatory application are key protections that all employees should know about.